Welcome back to another week of Gossip Without Prejudice. This is our main segment this week. We are doing Castle Rock versus Gonzales, which is a Supreme Court decision literally nobody likes, except textualists, which we'll talk more about that later. Lindsey, so glad to have you in studio today. Before we get started, support from the show comes from Hemmat Law. Whether or not you want to join a legal team or hire one, go to hemmatlaw.com/GWP. Similarly, thank you to our sponsors at Quimby. We've also got some fantastic support from, believe it or not, NordVPN, which is incredible. Go to gossipwithoutprejudice.com for more information. Lindsey, how you feeling today?
I'm feeling great. It's a lovely rainy day outside today. It's like a blanket, the clouds.
We are also, for those of you who missed our priors, are in our new studio this week. We've still got the duck.
Yes.
We're going to be slowly working to decorate the space a little bit more. We focused on setting up the hardware and getting our own table and stuff.
Yeah, we're like, we got to get our own space. Who cares what it looks like?
But we're still working on setting it up, but we're very excited to be bringing stories to you completely in-house now. Yes. We're going to be settling on a production schedule very soon, and we'll get a trailer up on the channel so that we can communicate that with you guys. I've gotten some questions about when we upload because as a newcomer to the channel, it just looks like we upload like every fucking single day.
We're a little chaotic.
Yeah, we're uploading like 3 times a week. We have different segments. We still have to decide which segment comes out which day, which is why we have not announced that specifically yet because we didn't want to spread disinformation.
Again.
So with all that being said, do you want to jump into things, Lindsey?
Yeah, let's jump into this case. This is a doozy, folks. This one's going to be intense, and I'm really excited to hear John's thoughts.
So Lindsey has a quick overview of the circumstances, but I'm the only one who knows what's going on here. This is my first time examining. This is a very well-known Supreme Court case, but this is my first time examining a Supreme Court case. I'm not a federal practitioner. I do all my, our practices in state court. So please email us at gossipwithoutprejudice@gmail.com with feedback on how I did, because this is the first time I've ever done a case like this, so we're going to give it a whirl.
Yeah, and we'd love to hear from you folks, regardless.
Yes.
Any thoughts?
Yes,
So.
thoughts, dreams, opinions, aspirations, whatever you've got for us.
The nightmare you had last night, maybe?
Yes.
If it's interesting.
Yes. So to jump into things, the full title of this case caption is Town of Castle Rock, Colorado versus Jessica Gonzalez. So this is a case that has super far-reaching implications for citizens seeking protection from the government. It creates the precedent that police departments have no affirmative obligation to protect you as a citizen.
Which really, 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 really twists my brain in an unpleasant way.
So this case always
supposed to do?
Goes all the way back to the late 1990s. In 1994, the Violence Against Women Act, VAWA, was passed federally to provide state and local governments with federal support in responding to intimate partner violence. The same year, many states, including Colorado, where this case originated from, passed similar laws to promote more robust enforcement of domestic violence laws. Colorado created mandatory arrest provisions for multiple domestic violence situations and created a statewide registry for restraining orders ordered by the local courts. With me so far?
Yes.
Hell yeah.
Sounds good. I like all of those developments.
Now, this woman was named Jessica Lennon Gonzalez, a resident of Castle Rock, Colorado, obtained a permanent restraining order against her ex-husband Simon during her divorce proceedings, requiring the ex-husband to remain at least 100 yards, quote, 91 meters for your Euros in the audience, from her and her 4 children, son Jesse and daughters Rebecca, Catherine, and Leslie, except during specific visitation time.
Okay. So that was a question I had right off the bat. So the order applies to her and to the kids.
And all the kids. Yeah,
interesting.
So domestic court ordered, stay away.
Yep.
Get the fuck out of here.
Besides your court
mandated visitation time. Yeah.
Cool.
It was a restraining order. The restraining order had been issued by a state trial court weeks earlier in conjunction with respondents' divorce proceedings. The original form order, issued on May 21st, 1999, and served on respondent's husband, that this is the Supreme Court talking, on June 4th, 1999, commanded the ex to, quote, sorry, I hate this. Commanded the ex to, I'm quoting from the state order here.
Okay, thank you.
Not to molest or disturb the peace of I have to do this segment again. I'm sorry. Okay, take two. All right. The state court order ordered the ex not to molest or disturb the peace of Jessica or any child, and to remain at least 100 yards from the family home, including the children, at all times. The bottom of the pre-printed form noted the reverse side contained, quote, from the state, important notices for restrained parties and law enforcement officials. And I'm
Mm.
going to read you this language from the state order because it's relevant to the issues at hand. The pre-printed text on the back form included the following warning.
Okay.
Quote, a knowing violation of a restraining order is a crime. A violation will also constitute contempt of court. You may be arrested without notice if a law enforcement officer has probable cause to believe that you have knowingly violated this order. So it's a notice to the recipient of the order, in this case, Simon, the ex-husband.
And a notice to the police if this person breaks this order.
Perfect. Well, we're actually just about to get to that. The
Ooh.
pre-printed text on the back of the form also included, in part, quote, notice to law enforcement officials. You shall use every reasonable means to enforce this restraining order. You shall arrest, or if an arrest would be impractical under the circumstances, seek a warrant for the arrest of the restrained person when you have information amounting to probable cause that the restrained person has violated or attempted to violate any provision of this order, and the restrained person has been properly served with a copy of this order or has received actual notice of the existence of this order.
I like all of these developments. I like
Yes.
this. I like the clear stating that it is the law enforcement's duty to enforce this order if he attempts to break it.
And that language at the end there, actual notice or has been served with this notice. In the American system, you generally speaking cannot be punished for an order you were not served with.
Right. So if the court has made the restraining order, but you haven't actually received the paperwork, you don't know that you were put under a restraining order.
The idea is that you cannot be punished for violating a court order if you did not intend to violate it. And part of that intent analysis is whether or not you knew about it.
Yeah.
Because if you didn't, you can't intend to do something you didn't know was possible.
For sure.
On June 4th, 1999, the state trial court modified the terms of the restraining order and made it permanent. So it used to be interim, right?
Wow.
It was like, which is very common. It's like you
Yeah.
enter interim orders to preserve the status quo during divorces. It happens all the time here in Washington. But this court, the Colorado court, was like forever.
Wow.
Right. The modified order gave respondent's husband the right to spend time with his 3 daughters, 10, 9, and 7, or on alternate weekends for 2 weeks during the summer and, quote, upon reasonable notice for a midweek dinner visit arranged by the parties. Basically, a sporadic time with the 3 daughters, no other time supervised. Dude was crazy.
What about the son?
Not included in the order.
Oh.
The modified, but that's not terribly relevant for the story, but you're correct that the son was excluded. The modified order also allowed him to visit the home and collect the children for such parenting time.
Okay.
Yeah.
And it allowed him to do that specifically under the permission of the mother, right?
As arranged by the parties.
Okay, as arranged.
Yeah.
So he
Upon
couldn't
reason.
he couldn't come and pick up the kids with no notice and say, "Hey kids, we're going to the park today."
Yes, exactly. There was some we call them here in Washington, we call them 191 restrictions, which is basically it's a reference to an RCW revised code of Washington. Basically means you lose various parental rights due to risk of dangerous behavior, etc. Malfeasance of some kind.
You ever seen the show Dexter? Super quick question.
Is that where is the murder of murderers?
Yes, exactly.
Murder of murderers. Yeah.
The main character, Dexter's girlfriend, has an ex that sounds exactly like this guy. Ooh, does that get my blood boiling? Anyways, let us continue for the story.
He was a blood spatter analyst for like the Miami-Dade Police Department.
Exactly
right? Or
correct.
something like
That's
that.
what Dexter did.
Yeah.
Yep.
Now that's an old show. I
It
could
is.
rewatch that.
It's
sometime.
old. It's honestly, it's a lot of fun.
Yeah. Okay.
Nostalgic.
Then we get back to the case. At around 5 p.m. on June 22nd, 1999, respondent's husband that seems to have took the daughters while they were playing outside of the family home, which he was supposed to stay away from, 100 yards, 91 meters. No advance arrangement had been made for him to see the daughters that evening in clear violation of the restraining order. Now, when she recognized that the children were missing, she suspected the likely cause was that the husband took them. At about 7:30 p.m., she called the Castle Rock Police Department, which dispatched 2 officers. Right,
Okay.
officers come out to investigate. When the officers arrived, she had a copy of the restraining order and requested that it be enforced and the 3 children be returned to her immediately.
Yeah.
She showed law enforcement about an order that he was duly served with and said, "This has been ordered by the court. I'm not just some Joe Schmuck. He's had his due process. Arrest that man."
So far, everything is good.
Everything's good.
So
And the
far, I like this.
Yeah, inquiring minds want to know what could possibly go wrong.
Right.
The officers stated there's nothing they could do and suggested she call the police department again if the 3 children did not return by 10 p.m. That was it. That's all they said. They just said, we didn't want to. No specific reason. In all my research for this, the police, why they refused, I think they just thought she was hysterical and just didn't care. At approximately 8:30 p.m., Jessica talked to her husband on the phone.
Okay.
He told her, quote, he had the 3 children at an amusement park in Denver.
My amusement park guess was correct. Anyways.
She called which is actually true. She called the police again because at like 8:30 p.m. this time she has concrete evidence and said, please have someone check on the kids. I know where they are. Yes. He admitted to having them. Her husband are in his vehicle. She gave them details on his plates and told him where to check in the amusement park and to put out an all points bulletin. Yeah. Please do something for her husband. But the officer whom she spoke on the phone refused to do so. Again, telling her to wait until 10 p.m. to see if her husband returned the girls. That was it. Police were just like, I don't know, he's going to return them. Not a big deal.
This legit makes me want to cry for this woman and these children.
Yeah, and it was tough. It was tough for Miss Gonzalez at approximately 10 p.m. After she waited until 10 p.m. Respondent called the police. Respondent called the police and said her children were still missing, but she was now told to wait until midnight. They moved the goalpost.
No! Oh my goodness.
They moved the goalpost. They just said, wait until midnight. Not important enough. She called at midnight and told the dispatcher her children were still missing. She went to her husband's apartment and finding nobody there. And remember, at 12 a.m., no one was home. That's weird.
That's a bad sign.
Called the police at 12:10. She was told to wait to an officer to arrive, at the apartment. None came.
Wow.
No police officer came.
Gosh.
She went to the police station at 12:50. It's now almost 1 a.m. and submitted an incident report. The officer who took the report made no reasonable effort to enforce the order or to locate the 3 children. Instead, he went to dinner.
Huh?
Yep.
What? What do we know where he went for dinner?
Well, I'm sure I could look into it, but the point is he didn't do shit.
Probably Applebee's.
It was like 1 a.m. So like, where was he really gonna?
Denny's.
Yeah, where was he gonna go? It's the $5 margaritas. So to recap, she at like 5 p.m. he took the kids ish. And then at 8:30 p.m., he's like, I have the kids. And then he goes missing for like 4 hours. And this whole time she's calling the police. She's even at this point showed up at the precinct and is like, please do something. Do something, you idiots. At approximately, sadly, this all comes to a head. At approximately 3:20 a.m., the respondent's husband arrived at the police station and opened fire with a semi-automatic handgun he had purchased earlier that evening.
Whoa.
Police returned fire, killing him. And inside the pickup truck, they found the bodies of all 3 daughters who he had already murdered.
Jesus Christ, man. So, okay. Did any police officers get injured in that shootout? Probably not. Otherwise, we would have heard about them, right?
Well, I don't think so, but that would be irrelevant to this case because this is a case, I'm going to be going into the procedural case shortly, but this is a case Ms. Gonzalez brought against the town.
Boy almighty. All right, I'll let you continue.
Yeah, so she's left with all 3 of her daughters are killed. Her husband is also killed, which means he can't face justice.
And the son is the only one she's got left.
Yeah, and it's her and her son. It's the only 2 that have been left alone. So this brings us to what she does after she loses pretty much her entire family. Rest in piss to that ex-husband.
Seriously.
On the basis of ongoing factual allegations, she brings an action under revised statute section 1979 and 42 USC 1983, claiming that Castle Rock, the town, the municipality, violated her due process clause rights because its police department, quote, had an official policy or custom of failing to respond properly to complaints of restraining order violations and, quote, tolerated the non-enforcement of restraining orders by its police officers. So that's pretty easy.
Yeah.
I can talk you through 42 U.S. Code 1983, civil action for deprivation of rights. Now, this is a federal statute who reads, in relevant part, it's going to get pretty wordy, so stay with me now. Stay with me. Under person who, under color of any statute, ordinance, regulation, custom, or usage of any state or territory or the District of Columbia, subjects or causes to be subjected any citizen of the United States or other person within the jurisdiction thereof to the deprivation of any rights. Stay with me. We're not even halfway through yet. Privileges, immunities secured by the Constitution of laws shall be liable to the party injured in an action at law, suit, or equity, or other proper proceeding or redress, except that in the action brought against the judicial officer for acts of omission. So basically what that very says is that like any person who under any color of statute of law basically deprives you of any rights, privileges, or immunities shall be liable to the party injured.
Beautiful. So that's a direct statement of these police officers should be
Yeah, like you had a duty
consequenced.
to enforce these rules.
Yeah.
You're liable.
Yeah.
I can't get my kids back, but give me money. It's really her only option.
Wow.
Yep.
Okay, well, that's a great start. I like that this law is on the books. So
Yes.
what is she doing with this?
The complaint also alleges that the town's actions, quote, were taken either willfully, recklessly, or with such gross negligence as to indicate wanton disregard and deliberate indifference to her civil rights.
Yeah. Gross negligence. Thumbs up from me.
So the procedural history here, this is a Supreme Court case, so we've got to walk this all the way up from the trial court through the appellate. Before answering the complaint, defendants, which is in this case
The city, right?
the government, basically, filed a motion to dismiss under Federal Rule Civil Procedure 12b-6. Not going to get into that because we've got a lot to chew on already, but basically they filed a motion to dismiss. The district court granted the motion, concluding that whether or not construed as making a substantive procedural due process claim, respondent's complaint failed to state a claim upon which relief could be granted. But wait, a panel of the Court of Appeals affirmed the rejection of a substantive due process claim, but found that the respondent had alleged a cognizable procedural due process claim on rehearing en banc. A divided court reached the same disposition, concluding that respondent had a protected property interest in the enforcement of the terms of a restraining order. Basically, district court said, no, you're out of here. And then appeals court said, actually, yes. And en banc, a rehearing review at an appellate level basically means they have another review, like it's like another hearing. It's something you rarely hear about. It's when the appellate courts are grappling with something particularly complex, and we'll get into why. But I think this is such a great case I want to talk about because it highlights the clash between the thoughtful reasoning of the judiciary sort of collides with common sense and like gut justice. Because like if you as a citizen want your rights to be protected, you'd think that protection orders and to protect and serve should be more than like a slogan, right?
Yes, absolutely.
The police
that should be a
departments-
duty.
Yeah, police departments constantly position themselves as like these vanguards.
Yes.
But the government consistently backs off from that commitment. And en banc is French for on the bench. Basically, a term refers to a special procedure where all judges are, hear a particular case when the court believes the matters are especially complex. En banc procedure will be used, rarely applied.
Got it.
And then so that brought, and then the Supreme Court granted certiorari. Certiorari is basically after after an appeals court of any circuit rules, be it the District of Columbia, the First, Fifth, whichever circuit, you can basically ask the Supreme Court to take a case, and the Supreme Court can grant or reject cert, which basically means they agree to hear it.
Yes, we'll take it or no.
I think 3 out of 9 justices have to vote just to hear a case, and then it goes on the next calendar, and then they consider it an oral argument.
Okay. So her case went to the Supreme Court.
Yep, and she lost.
Wow.
Yeah. The Supreme Court, I'm going to walk you through the Supreme Court's reasoning here, but ultimately the government was not held liable for any actions for Ms. Gonzalez or her children. The U.S. Supreme Court reasoned that the due process clauses, procedural components, do not protect every government benefit, only those where an individual has a legitimate claim of entitlement. The court found that a benefit is not protected in entitlement if officials have discretion to grant or deny it. So basically, remember, you and I have talked before about how the Supreme Court in its conservative, the Justice Roberts era, has been more and more focusing in on like traditions generally held in American establishment when making general rulings. It's been happening more and more over the last 20 or 30 years. This was back in 2005, so it was a little more backed off then. But basically, they're saying that like it has to be present in American society. What have we done historically, right? Which sounds good.
Precedent.
But what the Supreme Court hung its hat on here, I'll walk you through it. So the court determined that Colorado law did not create a personal entitlement to enforcement of restraining orders as police officers retain discretion in enforcement matters. So the court noted that a tradition of police officer discretion existed alongside seemingly mandatory arrest statutes, included the statute did not mandate officers to enforce the restraining order in a specific manner. The court emphasized that even if the statute suggested mandatory enforcement, it did not necessarily create an entitlement of enforcement, and the statute did not indicate such a right. So basically, trying to summarize here, it's like police officers have throughout history had discretion about how to go about their duties. And so we are playing we are playing games here, semantics.
Yes.
Scalia wrote the opinion. Scalia, for a majority court, and a per curiam opinion, basically said that like the reason we're benefit versus entitlement is that under the Due Process Clause, the 14th Amendment, the partaking of property, that this quote unquote property, like deprivation of rights under this case, all comes down to whether or not it's a benefit or an entitlement. And the court reasons that like if his officers have historically been able to withhold that and just go about their duties with discretion, then therefore it's just a benefit. It's just something nice. It's not a duty. It basically walks police officers back. And so that because that historical precedent has coexisted with mandatory enforcement before, that means it doesn't exist now. Yeah.
Wow. I really deeply hate this one, folks. This is intense. The idea that a person can be given this order and this order is recognized by law and should be enforced, but then at the exact same time, it is recognized by law that no one has to enforce this.
Yeah. While this argument might make sense in context in which police officers must determine whether restraining order was truly violated, like making that yes/no call.
Yeah, sure. Yes/no call. That's important. They need to have the wherewithal to be able to do that.
But here, generally speaking, the decision came down on the yes side. Like no one disputes that this was an enforcement situation,
yeah.
But despite that, court says no enforcement needed. Simon had clearly entered the front yard of the home and seized the children. The discretion emphasis that we have placed here on officers did not seem necessary to me. Here's the opinion part of this. So the court could have, this is just me talking, you're welcome to disagree. The court could have taken another route when they said, you know, the attempt, like you have to attempt to help or review the situation. And then that, if you do not attempt to, then that, you know, violates your 14th Amendment rights.
I see.
But they did not go that far. They also argued, the court, Scalia argues for the majority opinion, beyond the argument about affirmative obligations, the court held that the police had no obligation to arrest Simon because, quote, his whereabouts were unknown to the police, even though the police were aware of Simon's alleged location in addition to having his vehicle description and home address. Scalia goes on to argue that in certain instances where whereabouts are unknown, police officers are only obligated to seek a warrant rather than actually effectuate an arrest. Quote, the practical necessity for discretion is particularly apparent in a case such as this one, where the suspected violator is not actually present and his whereabouts are unknown. A mandatory duty to investigate would be completely open-ended as to its priority, duration, and intensity. So this is the court basically saying this is too big of a job for the government. We need an escape hatch because a mandatory obligation would be basically too much, is what the courts are saying. What the problem with this is that the courts don't replace that obligation with anything, and so it basically hangs our citizens out to dry. Justice Scalia uses the ambiguity of police obligation to argue that Ms. Gonzalez was not entitled to enforcement, saying that even if enforcement is truly mandatory under Colorado law, quote, this would not necessarily mean the respondent had an entitlement to it. Scalia used the ambiguity of police obligation to argue that Jessica Gonzalez was thus not entitled to enforcement of a restraining order, saying that even if enforcement is truly mandatory, which remember they ruled it wasn't, this is the second thing, under Colorado law, quote, that would not necessarily mean the respondent has an entitlement to it.
Ooh, wow. Then why does she have a protection order if she's not entitled to response?
In Board of Regents of State Colleges versus Roth, a 1972 case, the Supreme Court held that for an individual to have a valid property interest, remember, in this case, property ties to the 14th Amendment, in a state-provided benefit, they must, quote, have more than an abstract need or desire for the benefit in question, and instead a, quote, legitimate claim of entitlement to it. That's where the Supreme Court is hanging its hat. It's basically saying, because this is a benefit, right? Because remember, it's discretionary, quote unquote discretionary. Police have historically had discretion whether or not they enforce these orders. Therefore, it's a benefit as a citizen and not an entitlement. And therefore, 14th Amendment doesn't apply. And therefore, Jessica does not have any claim under 18 U.S. Anyways, yeah, pretty much. Basically summed up in a sentence that I wrote last night in a fever dream. The entitlement is critical to Jessica Gonzalez's case because whether her expectations of having her restraining order enforced is a, quote, entitlement or simply a, quote, benefit defines whether the restraining order's enforcement is considered property under the 14th Amendment.
Huh. Okay.
So that's the constitutional hook. So that's where the court hung its hat, is that because benefit versus entitlement, It's a benefit, therefore all bets are off. Police don't have to help you.
Wow.
Mhm.
Hate that. Hate that. This to me feels like the exact opposite of justice. And that being said, I'm someone who's never been a part of the legal industry. I don't have expertise on what justice means. But as a citizen of this country, I am infuriated by this precedent.
I mean, you've put your finger right on it. If Scalia argues a restraining order's value lies in the threat of potential sanctions, which is basically he does acknowledge that,
Yeah.
but the government has no obligation to actually make those sanctions a reality. The restraining order's threat, unless its value to the protected, is pretty meaningless.
Null and void, basically, because you're saying, oh, well, you did this thing. Well, your restraining order doesn't actually count. So
Yep. So there was actually this case wasn't a total shock. The context of the per curiam review was that there was actually a similar case called DeShaney v. Winnebago County Department of Social Services, which basically the same fucking thing happened, but with local child protection officials. They got a bunch of warnings that a child was being beaten by his father, and they ultimately did nothing, and then the kid ended up with severe brain damage.
Wow.
And there the courts also said, but though for different reasons, it was a little bit of a different context. Basically, they also said not liable.
Different contexts make that one a little tough because I don't know about CPS and their obligations, but police officers.
Yes. DeShaney v. Winnebago was bad, but it is not. It was famous only for being the stepping stone to get to Casa Rock v. Gonzales.
Sure,
we could go over that case, but it's basically just like a smaller version of this.
With a different government body.
Yeah, different government body. But I'm going to read you the entire ending paragraph.
Okay.
Of Scalia's opinion.
Let's see what this bullshit says.
The court concludes, quote, in light of today's decision and that in DeShaney, the benefit that a third party may receive from having someone else arrested for a crime generally does not trigger protections under the Due Process Clause, the 14th Amendment, neither in its procedural nor in its substantive manifestations. This result reflects our continuing reluctance to treat the 14th Amendment as a font of tort law, but it does not mean the states are powerless to provide victims with personally enforceable remedies, although the framers of the 14th Amendment and the Civil Rights Act of 1871 did not create a system by which police departments are generally held financially accountable for crimes that better policing might have prevented. The people of Colorado are free to craft such a system under state law.
Wow.
And I honestly think that's the most telling out of all of this, is basically they're saying, like, we don't want to be held accountable financially when things go wrong. And we being the government, the sense of the government royal we, because ultimately the courts are parts of the government.
Yes.
And the government will always, in the long run, unless forced to by the citizenry, will always try and protect itself.
Yes.
It's notoriously hard to sue the government unless the government has basically consented to, which I should tell you about how that process works. You literally have to ask the government before suing them. Even if it's permitted by statute.
Some bullshit.
Yeah, that's a whole other thing.
Yeah, we could get into that. Let us know if you'd like to hear that.
And then it continues. Finding for the plaintiff would blur the line between the property right that is protected and the process created to protect it, and would federalize all mandatory state law procedural direction to law enforcement.
So they're saying, really, truly, in the end, this is up to law enforcement.
Yep.
And there's nothing that the feds will do about it.
Protect and serve is just a slogan. That's the big takeaway. Unless you have some specific state remedy, which, to be honest, no state wants.
Yeah.
No state wants to. Nope. No remedy.
And so this is it. And so any women in the future in this situation, consider yourselves abandoned by your government.
Yep.
That's how I see it.
Yeah. Scalia delivered the opinion for the court in which Rehnquist, O'Connor, Kennedy, Soder, Thomas, and Breyer, I always mispronounce that, joined. And then Souter filed a concurring opinion, which basically means I agree, but for different reasons. Breyer joined in that concurring. Stevens filed a dissenting opinion in which Ginsburg joined.
Yeah, I'm with Stevens and Ginsburg.
Now, funnily enough, she lost this case. Ms. Gonzalez did not recover anything, but she actually did join with the ACLU in a parallel small action. Gonzalez filed a petition with the Inter-American Commission on Human Rights saying that the inaction of the police and the Supreme Court's decision violated human rights for protection.
Yeah.
In a landmark decision, the Inter-American Commission on Human Rights found the U.S. government responsible for human rights violations against Jessica and her three deceased children who were victims of domestic violence. What does this mean? Nothing. It means nothing. So international bodies, I left this in here because international bodies are frequently referenced, like the International Criminal Court, the Human Rights Committee. They're they're just a bunch of people in a room.
It's just semantics. It's just words. They don't
Yeah.
actually have any power to enforce their decisions, right?
Exactly. And that's the point I wanted to make here, is that international bodies are anarchic. So most of the times they're just, but not just by the United States, by everyone. Most of the time they're just politely ignored at best.
Not surprising.
Yeah, exactly. And now I'm going to read you a quick portion from that dissent that Justice Stevens put together.
Okay, I'm looking forward to hearing this.
It's pretty short but poignant to exactly our concerns.
Yeah.
The majority's conclusion that a citizen's interest in the government's commitment to provide enforcement in certain specific circumstances is not a property interest is wrong. A citizen's property interest in a government commitment to enforce such an order is a real and worthy of protection. Luckily, I paused. A citizen's property interest in a government commitment to enforce such an order is as real and worthy of protection as a citizen's interest in any other important government service. The state statute's use of the word shall demonstrates that the legislature intended enforcement to be mandatory. It is unclear what stronger indication the majority thinks should be used. Under the law, the police are required to provide enforcement of the restraining order and do not have the discretion to ignore violations. The majority focuses instead on what type of enforcement is required. An entitlement may still exist when the content of the entitlement varies depending on the situation. Police enforcement of a restraining order is a government service that is one of the same value as other government services. Yeah. This case should be treated the same as if plaintiff had hired private security to protect her family from her husband.
Yes. Yes.
She clearly would have had a property interest in the contract in that scenario because plaintiff's entitlement is based on a statute and a judicial order instead of a formal contract does not provide a rational basis for failing to see it as a protected property right. So basically, Stevens, I think, rightly points out that, like, hey, if you had hired a private company and they just fucking refused to show up, you'd be able to sue them for negligence and damages and a whole bunch of other stuff for violation of your private contract. But because it's the government, we're basically giving the government a free pass. And I think the important thing about Castle Rock v. Gonzalez is that people know.
Absolutely.
Right? That they understand that the government is consistently walking back its commitments to you as a citizen, as someone who deserves safety and prosperity and security, and being physically safe is the foundation of all those things.
Yes.
And I think it's something I grapple with every single day because I do domestic violence work, or our firm does.
Yeah, you're in the heat of this sometimes.
And a lot of our work is in defiance of a government that often does not care about its citizens. And what you need to know, the big takeaway, is that this is going on.
Yeah. Yep. And for me, the big takeaway personally is that protect and serve does not require protect and serve.
Yeah. Just a slogan.
As a white woman, I personally have felt over the course of my life, the police are here to protect me. And then now, lo and behold, they're not even here to protect me.
Yeah.
So that's
even with a court order.
Even with a court order.
Not even as like a private citizen.
Just with the court order.
Someone who's gotten a court order.
Wow.
It can not be enforced at any time.
Wow.
Yeah.
You know, I've known lots of people in my days. I've met a lot of different types of people, and I like meeting different types of people. And I could see this happening with the people that I've known, and I can see instances of this, and it's just deeply, deeply infuriating.
Yeah.
And I would love to hear our audience's thoughts on this too.
And our thoughts are with Miss Gonzalez.
Yeah.
I think this is a tragedy that was easily avoidable.
Yes.
The man was clearly extra psychotic, and her 3 daughters paid the price in the Castle Rock.
Yeah.
Police department did nothing.
I have not paid any price at all either.
Yeah. I'm also was just told by our sound editor, Sam, who's from Colorado, that the Castle Rock area also has the lowest rates of education in the Colorado metropolitan,
which is certainly interesting.
In our Colorado area. So, who knows what the what the state of affairs is out there, but you know, I think we should just keep fighting for a better future and talk to your legislature, because legislatures, in theory, can, you know, influence this stuff.
So, super quick question as we come off of this here. What about the future? I mean, is there any recourse for this to change?
I think at this point, this would require
a whole nother Supreme Court evaluation, right?
Well, basically, this opinion is also controversial. Make no mistake. Everyone isn't like just lying down and taking it. I think big recourse is that, like, your state can, in theory, pass legislation that makes the police, like, has stronger, more specific language that makes the police specifically liable.
Okay.
But that's basically just a question of police reform.
Yeah, and that's up to state by state.
Yeah, police basically fight this sort of stuff all the time, and even if they didn't, legislatures don't like making the government directly financially accountable to its citizens.
Yep.
And there's not really much recourse here other than another Supreme Court review.
Wow.
For this specific issue, unless the state by state, there's no clear path forward. There's a variety of paths, but none of them are clear or likely.
Wow.
So I'm going to be honest and say, watch your back.
Yeah, we just don't know.
This is the sort of thing that Gossip Without Prejudice seeks to not solve, but at least uncover. Arming you with knowledge is how we get better as a society.
Yes, absolutely.
Particularly in the era of post-truth.
Yeah.
Yeah.
Post-truth. I haven't heard that before.
Sadly, I have. And that will wrap up this week's main segment, everybody. Thank you so much for joining us. I'm sorry that we had to bring such bad tidings. But I hope you at least learned something somewhere in this segment. Go to gossipwithoutprejudice.com, support our show. Pledge of as little as $5 a month will keep our lights running. You can join our community.
Yes.
Anything else you need to know, go to hemmatlaw.com/GWP. Thank you to our sponsors, Quimby Bar Prep and NordVPN. Find more information at gossipwithoutprejudice.com, and you will hear from us very soon. Thanks so much.
Thank you so much for sticking with us through this one, folks.
Yeah, particularly through that USC co-read. That was a tough one.
Yeah, and we'll look forward to seeing you in the next episode.
Thanks, everyone.
Bye.